Hi, this is Caren Enloe. I'm a partner with SmithDebnam in Raleigh, North Carolina, where I lead our firm's Consumer Financial Services Litigation and Compliance Group. And I am really excited today to have with me two of my good friends, Leah Dempsey from ACA International, where she serves as Vice President and Senior Counsel for Federal Affairs, and Eileen Bitterman, who is the Compliance Officer and a shareholder at Weltman, Weinberg and Reese in Cleveland, Ohio. And we're here today to talk to you all about current trends in debt collection and what we have been seeing this year. So welcome, friends. It's good to see you. Mm-hmm. I think we kind of narrowed it down to 4 topics today. We're going to talk about legislative initiatives, and then we're going to talk about the anticipated release of the debt collection rule, which comes after 5 years of gnashing of teeth. And then we're going to talk about COVID impacts on debt collection, because I think it's kind of dominating the conversation and everything that we all do. And then finally, we're going to talk about a couple of Supreme Court cases that are lurking in the future that impact debt collection. So starting off, Leah, you're in D.C. Can you talk to us about a little bit what's going on? I know the House Financial Services Committee has been really busy. In fact, a couple of weeks ago, I saw that on September 23rd alone, the House passed 10 bipartisan financial services bills. So can you tell us a little bit about some of these bills and the actions you've seen that may be relevant to our AFSA members?
Sure. And before I begin, I just want to say thanks so much to AFSA for having me. I really enjoy working with Celia and Bill and Ann, and you guys just have a great team that I really respect in DC, and also just really thrilled to be here with both Caren and Eileen, who I have a tremendous amount of respect for and are really well-known attorneys in our industry. But turning to Congress, and to your point, I think at this point we're up to about 24 debt collection bills and credit reporting bills. It's really been a big focus of the House Financial Services Committee this entire Congress. This time last year, last September, there was a hearing specifically focused on the CFPB debt collection rule. In both the CARES Act first draft and the HEROES Act draft from the House, there are several sections in there that impact the debt collection industry. And I can tell you that if what was in those drafts, particularly the CARES Act draft coming out of the House, had become law, it would have been extremely problematic for ACA members, but also AFSA members as well. One thing of note is that in that it would have extended the FDCPA to creditors as well. So there would have been a whole host of new compliance burdens and issues. In the HEROES Act, there's also several provisions in there that would impact AFSA members, also extending the FDCPA to creditors, notably multiplying damages in the FDCPA by 10 times, pretty much stopping the ability to engage in litigation at all, including the ability to garnish wages, and things like requiring specific dollar amounts and timeframes for payment plans. So really things that would have a huge impact on the ability to collect at all. The good news is these bills are pretty much dead in the Senate right now. Even the HEALS Act, which is the Senate version, doesn't include those sections about debt collection. We actually don't even think the HEALS Act is probably going to move forward at this point before the election. Really looking ahead to, at this point, probably after the election, to see what happens in the lame duck and any possible negotiations that happen there. So that's kind of the landscape, a lot going on, and a lot of bills that impact third-party debt collectors, but I think first parties as well.
Well, Leah, I mean, we've got election in, I think it's in a month, right? What do you think's going to happen if there's a change in leadership, if we get a turnover and the Dems take control?
Well, one of the first things that comes to mind is the debt collection rule. I think this will be squarely in the crosshairs of a new administration, particularly in light of the seal of law decision. We know that Director Kreninger would probably be gone, and the House Democrats would very likely attack the rule. This is one of the first rules that Director Kreninger has worked on from start to finish, and just because of that alone, it's potentially subject to a Congressional Review Act challenge. one thing that's kind of interesting about the CRA challenge is that you may recall from the arbitration rule, if it is struck down, you can't do a rule that's substantially similar. So you'd have to think, would the Democrats really want a rule with call caps to be struck down and then in the future potentially not be able to do something substantially similar in a rulemaking? So there are all of those issues at play. But nevertheless, I think that the precedent has been created under the Republican administration that rules can be changed. We've seen that with the payday rule and several of the mortgage rules. And I think we can expect that Democrats will likely find a way to change the debt collection rule either at the CFPB or through legislation. We saw several bills during the all Republican chambers of Congress making changes to the mortgage rules. And I think we could expect potentially the same. We could see them maybe taking aim at some of the provisions that may be seen as more business friendly through legislation. So those are just a couple of high level thoughts, but I think there's going to be a lot of activity, including the filibuster potentially going away if there's a Democrat sweep. So we're going to be busy.
A lot to look forward to, maybe. Yikes, doesn't sound. Well, that thank you for being our ray of sunshine on that issue. Let's turn to another issue that has its pluses and minuses, and that is it's finally almost here, the debt collection rule. I think we have all three spent the last 5 years waiting and gnashing our teeth together as we've looked at advance notice of proposed rulemakings and supplemental proposed rulemakings and SBREFA, all of the things that have gone into this debt collection rule. And it's been a long road, but seemingly it's October and we're now here. It's time. According to, if you look at the 2020 spring rulemaking agenda, according to that, we've been promised a debt collection rule this month. And I think it's looking likely by the end of the month we're going to have one. But Leah, you're in DC, what are you hearing about that? Do you think it's still coming this month?
I would agree with you. I think we're going to see it soon. I think definitely by the end of the year. The Bureau seems like they've really been hitting their marks this year. They got the payday rule out. They got the HMDA rule changes out. The only thing that makes me think maybe not this month is because of the election. It's always, throwing a new rule into the election mix is maybe problematic. But if not this month, I think definitely next month, and it's finally here. Well,
do you think it's going to be, typically the proposed rules and the final rules have pretty similar. I would give them about a 95%, mirroring rate. Where there's 95% what's in the proposed rule is in the final rule. Do you think that's going to hold consistent? Now, I think this is, really one of Kraninger's first major rules. Do you think that her CFPB is going to hold consistent with that, or do you think there's going to be big changes? And what do you think is going to come in or come out?
Yeah, just a couple of thoughts on that. At a high level, the debt collection industry, we were just happy by the fact that it finally recognized modern communications. For a long time, we've been wanting to send emails and text messages, and we're happy that the rule at least does that. And I think those will most certainly be included in the final. However, I do hope that they take some of the feedback that us and others provided about some of those sections, because I think there are some barriers to it really being fully accessible to everyone. For instance, under the email section, it said that you could not send them to work emails. But right now, there's really not a vendor that can differentiate between a personal email and a work email. And I'm not sure that could ever even happen, because I don't know that we would ever know how someone's using their Gmail. So an issue like that, I hope that the Bureau, when taking a closer look, realized that would definitely be a problem, and really be particularly problematic, I think, for the smaller agencies that might not have a compliance program that they can easily put in place for that. Another thing, I'm hoping that they finally give us the clarity we've all been looking for on this voicemail issue and finalize the limited content message. that would be extremely important to our members, and I know others as well. And one other piece where I hope they take another look at is the itemization piece. I know from particularly the medical community, they really thought that that would be a huge barrier for them to be able to do that. And I think the same could be said for AFSA members. We've estimated that it could be an extremely costly compliance burden to do that itemization. And we're hoping that they've maybe taken a second look at that. And the other thing that gives me a little bit of hope in that is that that will be part of the model validation notice, which is also in the time bar debt piece. So I'm hoping that maybe they just hold off on that piece for now and kind of think it through a little bit more as they kind of contemplate time bar debt. However, those are my wishes. I don't know if they're true. It may look exactly the same as the original version. As you said, that has happened frequently before. We've seen that in the arbitration rule and several other rules. So I guess hopefully we will see soon.
Yeah, I'm kind of with you on that. I think that there's a couple of things that may look a little bit different. And I think there's going to, I'm curious to see, and I don't know if you've heard anything as to whether the supplemental rule, proposed rulemaking that came out this spring on time bar debt, whether you've had any indication that that's going to come out with the final rule or whether that's going to be held back a little bit.
I've heard that's probably going to be held back and be a separate piece that might come out next year.
So I think a couple other things I think that that we need to be aware of, particularly I think there's some ultimate impacts for creditors I think that are going to be interesting to see whether or not they're in the rule. And since most of our AFSA members are original creditors, I think most everyone's aware that there were some provisions in the rule because of the way the rule was couched in terms of there was 4 provisions of the rule that arose under the Dodd-Frank authority and not under the Fair Debt Collection Practices Act authority. There was there's some question as to to what extent the intention is to make the rule applicable directly to creditors. And I suspect we'll see some clarification on that piece of it in the final rule. I think there are, but even without that, I think irrespective of direct coverage, I think that there are some things that our AFSA members need to be aware of, that there are going to be indirect impacts for them, and that's primarily in how that they deal with their vendors, be it a third-party collection agency or that it's a law firm. And I think 2 of those to really look at and be aware of is thinking about the forwarding requirements. When I'm talking to my clients, I represent both direct financial service providers as well as collection agencies, and just talking to both sides of that conversation. And one thing I've made them aware of is to make sure that they are talking about what's going to be in their forwarding package. And this goes back to the itemization date. As you all remember that there's a requirement now in the rule that's not in 1692G that talks about an itemization date, and collection agencies or third-party collectors, debt collectors, having an option of 4 different possible dates that I think were designed to really kind of impact, to look at what type of debt it is. But irrespective of that, it's going to require a lot more cooperation and communication directly between original creditors and their third-party vendors, because they're going to be, the creditor's going to be the person that's in the best position to determine what that itemization date is. And then the creditor, the third party, is obviously going to have to then provide that itemization from there. I think the other significant direct impact for creditors is going to be on the electronic communication piece, and whether or not there's been consent provided and how that consent is going to be documented. And I know, Leah, I think you and I were at lunch about a year ago, about right now. Remember talking about the debt collection rule, and we were talking to a credit card provider, and we asked them how their e-sign act compliance management system was, and the look on their face was priceless, because it was like, yeah, we struggle with that already, and now you're asking us to add the second piece to that. So I think that there's a lot in there that, irrespective of whether it's directly applicable to first-party creditors, I think it is certainly going to be have some indirect impacts that they need to be aware of. So Leah, I think you answered the other question I was going to ask you, is what you thought was going to happen with the time bar debt piece, and you think that's going to be delayed?
I do think it's going to be delayed, but I will say that we're pretty concerned about that piece, especially since there's no preemption. We think it could create some problems. So that's on my list of problems coming my way in 2021. But for now, I think it's probably going to be more focused on the NPRM.
Well, I guess we'll see, and I guess we'll see really soon. I think we're all I know the three of us are going to be very, very busy for the next 12 months as we try to ramp up our clients and our own businesses to deal with these issues. Well, I want to turn to something else, which is something that we've all been living with, and that's our little friend Rona, as in Corona. And Eileen, you're a compliance officer and an attorney in a law firm, and I bet you've been having just the best time of your life. How's the pandemic impacted the structure of your compliance management system, and just in your experience with debt collectors and creditors generally?
Sure. First of all, I want to say I'm honored to be here speaking with Caren and Leah, two people I greatly admire as well. And I hope everyone out there is doing well during these extraordinary times. And as Caren has indicated, yes, the coronavirus, the pandemic has definitely been a focus for us here in the debt collection industry. As we all know, we all have what are called compliance management systems since the CFPB came on the scene. A compliance management system is something that has to be strong and effective for you to run your business. Well, it also has to be adaptable, and the pandemic has really taught us that. As far as a compliance management system for us goes, we need to have a couple of things that we focus on. So obviously we're focusing on our business strategy and our day-to-day operations. So with the pandemic, we have to make some accommodations to that. We also are focused on having that CMS be in compliance with state and federal regulations. Again, we are having to have some temporary adjustments to that based on things that are coming out. And finally, of course, the CFPB wants you to be focused on mitigating any consumer harm. So now we're looking to, again, enhancing those hardship and deferment type policies and procedures you've had in place. So just as a level set, as a reminder, your compliance management system has to have that board and management oversight. You have to have your policies and your procedures in place. And once you've created those, you have to make sure that you're training to them and that you're educating not only your clients and your employees, but also your vendors on them as well. Certainly, you have to have the component that focuses on a consumer complaint process so that you can look at any of that trending that's occurring. And then finally, of course, you have to have that audit component, both the internal audit and that third-party oversight. So as you're looking at your compliance management system, you're looking at what is the guidance for those policies and procedures you've created. Well, as we all know, over the years, they're not set in the Fair Debt Collection Practices Act. You have to create them. So you look to that law and other federal and state laws. We've been looking to the CFPB and their manuals and their modules. Certainly you look to client work standards as well to guide those policies and procedures. But in the last several months, we've also been looking to healthcare organizations, the courts that are actually putting pauses on some of the things that we are allowed or not allowed to do currently, the governor orders that are coming out that are governing different states about what you can do in our industry, the attorney generals as well. So all of that has to be looked at within the confines of your policies. So when I look at a policy, for example, called hardship that we've all had in place for a long time, certainly our focus in this industry is to show empathy and understanding to those consumers to try to get to a resolution. That is what we're trying to do when we work an account. So we've always had a hardship component, but now I have a COVID-19 hardship category, and I needed to create and update my policy, and I needed to create a status code, and I need that to report to my clients, and I need that to show up in my notes on my accounting system for the conversations that my collectors are having with these consumers that have these COVID-19 concerns and are asking for this type of temporary hardship. Same thing with deferment and payments. So you may have had a settlement concept in a policy or procedure that prior to the pandemic was working perfectly. Now, due to the pandemic, you need to adjust that a little bit because your clients want you to change that strategy and change how you do that policy. Same thing with legal actions. Legal actions, there's a legal process in the litigation. But now there is a pause, whether it's from the courts in your states or from your clients saying, hey, I know normally when we get to this point in the litigation, we have our judgment and we've made collection attempts. Our strategy is to use a post-judicial remedy. there's a hold, and you needed to, again, update your compliance management system to make sure that your policy is educated to all that are involved, knowing the hold is in place, making sure the programming is done so that you can address that type of an issue. Again, you're not creating completely new policies and procedures, but you certainly are looking to adapt your current policies and procedures with this new information that's coming out so that we can make sure that we're still serving our clients and the consumers in our best capacity with our compliance management system.
Well, that's a lot. I know we're seeing even down on the municipality level. I had one client call me one Friday night at 6 o'clock and say, can you look at these 3 counties because we have a call center there. It's something none of us have dealt with, and I think you just hit on the key, which is adaptability. Something else that's going on, I think we're all saddened by the death of Justice Ginsburg, but the Supreme Court will continue to hold court with 8 justices and not 9, at least for the forthcoming future, depending upon what happens. And there are 2 cases actually pending in the Supreme Court. You know, it's interesting, for like 10 years, there were like no debt collection cases whatsoever. And then over the last probably 8 or 9 years, there's been at least 1 a term. And, you know, there's 2 this term. One is a bankruptcy case, City of Chicago versus Fulton. And in that case is really going to look at an issue that comes up all the time. And that is a creditor repossesses a vehicle because the payments are delinquent, and then the debtor files bankruptcy. The question before the court is going to be, does the creditor have to automatically and without a request for turnover return that car to the debtor? Or is it a violation of the automatic stay to passively retain possession of the credit of the collateral until there has been a motion for turnover or an adversary proceeding seeking turnover? And there is a huge split in the circuits. It's 5-3. Last year, there were 2 cases, one out of the Third Circuit in Ray Denby Peterson, and one out of the Seventh Circuit, which is the City of Chicago case, which is for consolidated Chapter 13 bankruptcies. And that case is going to be heard later this month, and will have huge ramifications, I think, for a lot of AFSA members. So something to keep on your radar. It's bankruptcy. It's an automatic stay versus the turnover provision. They create a little tension, and I think it's going to be something to watch. And the other case is a TCPA case. You know, we just had one this past term, and now what I was pleased to see happen, and what I candidly had not expected to happen, was the second case that had been teed up, which was Facebook versus DeGuide, I believe is how you say it, also to have cert granted. And that was granted back in the spring and is set for oral argument in December. And in that case, they're going to directly take on the ATDS provisions of the TCPA. And the question that's before the court specifically is whether the definition of an automatic telephone dialing system and the Telephone Consumer Protection Act encompasses any device that can store and automatically dial telephone numbers, even if the device does not use a random or sequential number generator. And if you all remember, this is where the FCC came out a couple years ago and issued an opinion, and then that kind of the ACA challenged it. Thank you, Leah, and your colleagues over at ACA challenged that. And so this has been kind of sitting out there percolating. There's been some case law that's come out in a couple circuits that disagreed with it, but now that is going to be heard in December. So it's a pretty exciting time. And as Alexander Hamilton would say, what a time to be alive. And so I think it's going to be very exciting for us to see what happens. What happened this past year has been a year I don't think any of us could have imagined. And I think what's going to happen next year, there's a lot to, for the nerds in all 3 of us, and I know we all are a little bit nerdy when it comes to the subject, it's kind of an exciting time to be involved in this industry. And I think we're going to transition to questions and answers that may be coming in through the chat room. And we appreciate, on behalf of Leah and Eileen and myself, we appreciate your time today, and thank AFSA for having us.
Thanks so much, guys. Don't forget to join us at 4 o'clock for pub trivia. The first question is going to be, how many times did I remind you to come for pub trivia? Thanks.